turning to the substantive claim. For the avoidance of doubt, we agree that when Your Honour is considering whether a claimant brings a strong claim or a good arguable claim, consider both the underlying claim and whether that gives rise to an arguable proprietary claim. Excuse me. So far as the substance, the underlying claim, is concerned, I've outlined to Your Honour that in our submission the matter is relatively straightforward. The question is, how did it come about that Mr. Hague, Deputy Chief Executive, subject to fiduciary duties, found himself with, if I can globalise it, millions of dollars of our money, supported by a wholly fraudulent audit trail. Now, Your Honour will recall that in September, Your Honour made an order for a letter of request to the onshore courts in Dubai, which eventually bore fruit in January. Sir John Chadwick, of course, made a similar order in relation to banks in the United Kingdom as long ago as June of last year. So we're now able to track the payments into Mr. Hague's bank account. And we can see all of the fraudulent payments going in, and we can see them coming out again. And the majority of Mr. Patel's witness statement in support of the immediate judgment application addresses that exercise. Mr. Hague says this came about because he was being paid salary, expenses and commissions. Your Honour has the defence, and I think Your Honour has been marking the one behind divider 4 in the defendant's bundle for this application. And I know Your Honour has read that document.
Well, I've read it, yes. I mean, I have to be cross-examined on it. Yes.
But Your Honour has identified that that defence is wholly lacking in what it is said Mr. Hague's salary was. My friend refers to a document behind divider 10 of the bundle, this bundle, page 201. A number of points arise. I was wondering the extent to which Mr. Hague would in fact rely on this document. First, Your Honour notes that it's a reference, a salary certificate. It's not evidence of a salary, of a contract of employment or any sort of agreement. Second, Your Honour notices that it's not in fact a figure for Mr. Hague's salary. It is a figure that says it is in excess of £750,000 per year. It doesn't say by how much. And third, it is signed by Desiree Edwards, who gives her title as Office Manager. Now, if I could ask Your Honour to return to the defence. To go to page 22, the bottom right-hand corner. Paragraph 7. Over a period of time, the number of employees of the claimant was reduced in number from 45 to 6. The structure of the claimant in Dubai was as follows. Hisham, that's Mr. Al-Ray, is Managing Director and CEO. The defendant, Deputy CEO. Rana Higley and Cobus Foster, Head of Finance. Desiree Edwards, Part-Time Office Manager and PA to the defendant. So it appears that the only evidence put forward by Mr. Hay for his salary is a letter written by his PA to whom it may concern. The defence is wholly lacking in when it is said that the salary was agreed. By whom? What authority they have to agree it? What the payment terms were? Anything. It's wholly lacking in particulars of the level of expenses which Mr. Hay incurred, or is said to have incurred. I showed Your Honour the reference to the PwC report, which supports the notion that there was some expenses reconciliation, but is somewhat silent. But certainly the defence is silent as to which of these payments were for how much of expenses actually incurred. It's silent on the basis on which these expenses were paid. I.e., were they paid in advance or reimbursed following the delivery of receipts? It's silent on the method by which they were paid, that is, with the use of a corporate credit card or the use of personal resources. If it's said that they've been paid through personal resources, what those resources were, certainly his bank accounts don't show large amounts of expenditure for what are obviously business purposes. If it's said that the expenses were paid in advance, no particulars at all of what reconciliations there were. And then finally, although it is said that there's a counterclaim for anywhere between 4.8 and 6.2 million pounds, and at the same time that a number of these payments were payments of commission due, under the same, it would appear, investment agreement, the defence is silent as to which transactions it is said that particular payments represented commission on. So the defence appears, frankly, to fail to provide any meaningful particulars of any aspect of the defendant's case. And my friend...
So just, forgive me,
Yes.
for interrupting. In paragraph 29 of the defence,
Yes.
It identifies payments that he received of the classes in the sub-paragraphs.
Of the classes, yes.
Yes. Now, paragraph 16, 1 to 25, is paragraph 16 of what?
The particulars of claim.
Can I just see those?
Yes, Your Honour has the amended particulars of claim, which is perhaps the most appropriate. Additional bundle 1,
Yeah.
divided 2,
Divided 2. Thank you.
and paragraph 16 begins on page 12 in the bottom right hand corner.
Thank you, Tony. Right, I understand. So it's simply a reference to various figures
Yes,
of monies that were paid into
yes,
that are reflected in the invoices.
yes.
But all those invoices
In fact, all of
are expenses, according to paragraph 29.
well,
Or have I misunderstood it?
expensive.
There's no reference there to a payment of salary or commission or
There is paragraph E, 29E.
Oh yes, I'm so sorry. But that's not salary.
No, that's the commissions. Now, Mr. Hague both answers the claim and purports to bring a counterclaim or claim set-off by reference to what he says was an agreement whereby he would be paid commission on certain investments by the claimant. Now what Your Honour notices is that although paragraph 29E refers to 7 payments, it doesn't actually give any particulars, and it cross-refers to paragraph 65.
Well, I assume the particulars are cross-reference to the figures that are set out in some paragraphs in the particulars of pay.
Well,
i.e. this money was paid into my account. Yeah.
so there's no...
But he's saying it represents commission, although, as you say, of course, it doesn't identify any commission agreement.
Well, the only particulars that he gives of what he was entitled to is at paragraph 65, which is page 31.
Oh, yes, thank you.
And remarkably, given that this is apparently a contract worth 4.8 million, and we're now told Messrs Samuels may have found it to be worth 6.2 million pounds, no signed copy of this contract appears to be available.
Yes, so that's the commission referral fees.
Yes.
Is there any suggestion that any of these payments that have been identified by your client paid into the bank account of the claimant were in respect of salary?
In particularised, no.
It's all expenses, isn't it?
He asserts that
1 to 5 is expenses.
yes. Oh, paragraph
6 is
29, yes.
expenses. 6 to 17 is expenses.
Yes.
Yeah.
No,
And then 29A to C, I don't know what that is. And then 17 to 25 is commission.
yes.
So there's nothing about the salary or the bonus
No.
or the stock options.
No.
No.
And in fairness to Mr. Hay, of course, there were a number of suppliers whose identities were misused. And paragraph 29 refers to payments that are attributable to fraudulent invoices bearing Lincoln Associates name.
All right. Okay.
And there was a second one which was GPW. And on page 30, paragraph 53 of the defence,
Yes.
all of those are attributed to commissions or referral fees, but again without any reference to which transaction. And then page 31, this is counsel, reportedly. He says that he's unable to answer in relation to 3 payments, but he admits receiving the remainder, and he says those payments represent salary for his role as managing director of Leeds United.
Which
And
paragraph are you in?
Paragraph 61, page 31.
Oh, yes, I see.
But those payments represent
Managing
salary.
Director of Leeds United
Well, quite.
and expense payments.
Quite. But as you
What
might
due from the club?
Well, Your Honour might imagine that we take issue with why on earth it would be that the claimant was paying the defendant's salary at Leeds United.
Right.
And indeed, his agreement with Leeds United for a daily honorarium in his capacity as director is exhibited to Mr. Patel's third witness statement. But that's, by the by, no particulars are actually given. So, Your Honour will bear in mind, although Mr. Hayes...
Sorry, the Commissioner referral field total 4.8 million
Yes.
pounds. There are no particulars of the salary payments. And
No
the
particular.
payments that are, sorry, the monies that are identified in the points of claim of paragraph 16, I think,
Yeah.
all but perhaps
All but 7.
all but 7 of them are not referral or commission payments, not
Yes.
salary, not bonus,
Yes.
but expenses.
Quite.
And no particulars of any expense. No.
No.
Okay, understand.
Now, Your Honour will know that very much, quite apart from the obvious omission. Although Mr. Haig asserts that he has been disabled from defending these proceedings properly by a lack of access to documents, 3 points. First, the above omission, all of these omissions relate to the defendant's finances. He doesn't need disclosure from us to know what his own salary was and how it was paid. Secondly, those omissions relate to agreements which the defendant says he had reached. He doesn't need disclosure from us to know what he agreed when and with whom. Thirdly, all of these omissions, so far as commissions are concerned, relate to a specific agreement in relation to specific transactions. He doesn't need disclosure from us to know why he was receiving substantial payments into his bank accounts. And my friend...
Sorry, what your point there is, I'm sorry, not
Well, the point is...
It says the 7- agreement is one agreement. There's an unsigned version.
Yes.
Slightly odd. And then he's going to disclose the signed version when he has access to documents.
So he says, but of course Your Honour has seen 64 gigabyte flash drive moving around in reference to a server of documents.
But if the commission and referral, the commission referral fees total 4.8 million,
Yes.
then one has to add to that, does one? He's entitled to keep the monies which he says were paid to him for expenses and salary. So the total claim, or potential counterclaim, is entirely due to monies earned under one agreement.
Apparently so.
Yeah. Of which we don't have a
signed copy. Remarkably, it would appear, given its value, Your Honour, my submission is entitled to take account of this.
Yeah.
Mr. Haig is able to readily identify a draft of the agreement. We know it to be a draft because there are various details yet to be completed. But he's not able to lay his hands on the signed agreement himself. It's a very curious state of affairs. And one which no doubt Mr. Haig will explain in answer to our application for immediate judgment. But for today's purposes, Your Honour is entitled to my submission to have regard to the fact that the defence, such as it is wholly lacking in particulars. And indeed wholly lacking in the central document. In my skeleton argument...
So can I just understand paragraph 65A?
Yes.
By referral agreements between the claimants and 7-, I don't know who they are, 7- agreed to refer investors to the claimant.
Yes.
So far, so good. And in consideration of an investor making an investment in accordance with the contract,
Yes.
now that is, I don't know what the contract is.
It's defined in the next section, in the next clause.
Oh, I see. All right. So forget about that. In accordance with the contract, making investments in accordance with the contract, the referral fee would become payable from the claimant to 7-.
Yes.
So what
by subparagraph E,
Yes.
he then says by letter in or around November.
No, I see
2013.
assigned its right.
The company assigned its right to him. Now, we don't have a copy of that letter, and one has to ask what the purpose of 7- was if it was going to assign its rights to receive property, to receive funds to the defendant in any event. Why didn't they just reach an agreement with the defendant?
So, and that is after the referral fees have been earned, as I understand it.
Apparently so.
So the referral contract was dated before November 2013, and there were sufficient referrals to justify a fee of 4.8 million, and then the people who've done the work, namely Refer Industries to the claimant, then transfer the entire fee to the defendant.
And that's what it appeared.
Yes, okay.
In fairness, we understand 7- to be a vehicle for Mr. Hay, or said to be a vehicle for Mr. Hay, rather than an arm's length third party. And of course, the immediate question that arises is why on earth the claimant would be entering into an agreement with the company instead of with its employee directly. So it's an extremely curious state of affairs. My friend made much of a handwriting report. We found it, Your Honour. It is in the papers which you have. It is in our additional bundle 2.
Yeah.
And it is page 266 in the bottom right-hand corner.
Now this goes to the handwriting on the signatures of the
Yes.
invoices.
Yes. Now,
Invoices for expenses.
well, in
or
fact,
money anyway.
in fact, it doesn't consider any invoices. It considers payment instructions.
Oh, I see. Okay.
Which
So
aren't in
what was
fact
the
part
page
of the-
again?
266 is the cover page of the report. Now, I shan't take Your Honour through it in any detail unless I'm asked to.
So did you say 256?
266.
Oh,
I'm sorry.
enough one. Yeah, I'm with you now. Oh, I see. This is a copy of the defence. It actually has the documents that were said to be attached to it. Yes. That's a bit of an advantage. Yes, okay.
And so over several pages, Mr. Radley considers a number of signatures. And what he concludes is that in most instances, they are Mr. Hayes' signature. They are simply transposed from other documents. And in some instances, he's unable to give an opinion as to whether it is Mr. Hayes' signature or somebody else who has written. Nowhere is there somebody else's signature on any of these documents. Nor is there any clear finding that the documents are forgeries properly so described. Now again, Mr. Matthew deals with this in his third witness statement, and indeed we dealt with this before Mr. Justice Mayles, because Your Honour will note the date of this report.
Yeah.
1st of August of 2014. So it predated the first application for a freezing order in London. This report merely shows, if anything, that there was the capacity for people, whether the defendant or others, to electronically superimpose or by Xerox superimpose signatures on documents. That's hardly a revelation in our respectful submission.
Thank you.
And within this bundle of documents considered by Mr. Radley, there were instances where it appears the defendant, though I don't think they're exhibited here, there are instances where in genuine documents, so documents that were in fact sent to third-party suppliers, the defendant appears to have annotated fake and indeed attributed the forgery to Desiree Edwards.
Sorry, you've lost me on that completely.
So Mr. Radley appends to his report, but it's not appended to this copy, the documents that he considered.
Yeah.
Those documents include documents which were genuine documents in the sense that they were in fact sent to third-party suppliers and appear to be signed by Mr. Haig. But the copy that Mr. Radley exhibits has an annotation on it, the full explanation of which has never been provided, but we infer as the defendant's annotation, where he has written Desiree fake. In other words, that it would appear to be the defendant's case that his signature would be attached to documents, at the very least by Ms. Edwards, even on legitimate documents. So in our submission, this handwriting evidence goes nowhere. And Your Honour will recall that in September, Maloney Friend's predecessor was quite unable to assist Your Honour with how this really advanced the case, given that everybody accepted that the audit trail was fraudulent. Returning to the defence, Your Honour will have noted a significant number of allegations made against the claimant. And Your Honour will note reference page 21, paragraph 4C, Mr. Array is acting shadow director of Leeds United. Paragraph 5, I stand silent while Your Honour reads that. Paragraph 12 to 14.
Yes, paragraph 14 led to my question. Perhaps I've not quite grasped any of the detail of this. One can, I suppose, within the scope of that, the first two sentences, one can at least comprehend a system in which there was a practice of false invoicing to disguise from the Bahrain board and the CBB their involvement in certain projects.
Yes.
Why would they do it in relation to salary?
I'm afraid we're quite unable to give Your Honour an answer.
What possible motive could there be? I'm trying to think of one.
Your Honour, if this paragraph has anything whatever to do with the defendant's defence to the claim, we say it doesn't. It's just an unparticularised, gratuitous attack on the defendant intended to embarrass the claimant, rather intended to embarrass us. But if it has anything to do with the defence, then it must be that the defendant's case is as follows. The claimant and its parent company determined to conceal from themselves the National Bank of Bahrain, the Bahraini Stock Exchange, the CBB, and others, the level of salary, expenses and commissions being paid to Mr. Haig, for no apparent reason. In order to do so, it must be Mr. Haig's case, that an unnamed individual or individuals within the claimant set about creating a wholly fraudulent audit trail of payment instructions and invoices, in each case using the defendant's name to provide approval for the payment. Next, the same or other unnamed individual or individuals within the claimant must have made improper use of Mr. Haig's email account to send emails attaching fraudulent invoices and, alternatively, instructing payment, either internally to Mr. Matthew or to the claimant's solicitors. This is paragraph 19 of my skeleton argument on pages 10 to 11. And finally, it must be his case that he himself was wholly unaware that this scheme was in operation, notwithstanding the emails requesting the fraudulent payment were responded to at his email address. And Your Honour will also have noted that although Mr. Haig makes a number of allegations of systematic impropriety, he himself, on the part of the claimant, he himself as Deputy Chief Executive appears to have had no involvement whatsoever in any of them. So, Your Honour, so far as the underlying claim is concerned, we submit that we bring a strong, very strong prima facie case, and that the answer to it is at best incoherent, and at worst simply incredible. Turning then to the proprietary claim, a number of answers have been put forward to the proprietary claim in relation to the guy's solicitors' money. I don't know whether Your Honour recalls this issue of the guy's solicitor's money, but what happened was Mr. Haig lent £1.7 million odd to Leeds United Football Club. He did that through a company called Sport Capital Limited. That was a company incorporated in Guernsey. Mr. Haig was repaid, I think it was somewhere in the order of £700,000, 750, in 2 tranches. And the balance was paid shortly after Leeds United unsuccessfully resisted a petition for its winding up at the suit of Sport Capital. Now, what is said is that Sport Capital borrowed money from Mr. Haig at commercial rates, which it then lent to Leeds United. In fact, the money went straight from Mr. Haig's bank account to Leeds United. And it is said that at the time Sport Capital didn't even have a bank account. The money that was repaid following the insolvency proceedings came from a company controlled by the current majority owner of Leeds United. As I understand it, it is said that we have no proprietary interest in that money. The first basis, which was that put in evidence, was that because the money came from Eleonora Sports, which was the majority owner's company, we simply can't trace it. In my submission, the analysis is this. Because of the banking evidence, it's now clear that all sums lent by Sport Capital, nominally, were in fact provided by the defendant, and that all of those sums could be traced back to the fraudulent payments to the defendant's bank account. We submit that there could be no dispute but that when a fiduciary receives funds in breach of his fiduciary duties, he holds them on trust for his principal. If authority is necessary for that proposition, the issue was most recently considered in FHR European Ventures and Seeded Capital Partners by the Supreme Court in the context of bribes and secret commissions. And Your Honour has that in an authorities bundle that was passed to you only yesterday. That's right, then it must follow that all sums that were lent by the defendant to Leeds United were trust property, which he held for the benefit of the claimant, if our underlying claim is sound. There is no credible dispute but that Sport Capital is a vehicle for the defendant. In fact, it's had no activity that we can discern other than acting as a vehicle for the defendant to make the loans to Leeds United and securing repayment of those loans. We say, at the very least, Sport Capital can be inferred to be holding its assets for the benefit of Mr. Hague. It may be that it can be said to be simply a facade to conceal that Mr. Hague is a true operator, but at the very least, those assets are his beneficiary. But in any event, it's common ground that by a simple operation of a contract signed between Mr. Hague and the fiduciary who operates Sport Capital, every penny in the Guy Solicitor's current account is due to Mr. Hague under the loan agreement between the company and Mr. Hague. And so we say that whether, because the assets of Sport Capital are in truth the assets of the defendant directly, whether they're held for the benefit of the defendant, or because he's entitled to their repayment anyway, the defendant is entitled to all of the sums Guy Solicitor's client account. That entitlement arises because he applied trust property, our money, in making the loans. Therefore, we have a proprietary claim, whether directly, because they're in reality his assets, or indirectly, because he holds the shows in action represented by the claim against Sport Capital for the debt on trust for us. Now, Mr. Hague made a number of points about clean hands. I made a number of points about them at paragraph 22 of my skeleton argument. But I heard what Your Honour said before the short adjournment. And unless I can assist Your Honour on that line of answer, I don't propose to take any more of the court's time with it. In the skeleton argument, the defendant posits a third line, which is that because the money was lent, Leeds United, well, first Sport Capital and then Leeds United, became bona fide purchasers for value without notice that they were borrowing trust property. And so when the money was repaid, it cannot be traced. The chain has been broken by the interposition of the bona fide purchaser. Well, in our submission, there are a number of answers to this. The first is that it appears to be premised on the notion that when money is lent, the borrower becomes a purchaser for value of the money that's been lent, regardless of whether they ever pay it back or not. No consideration is identified for this proposition, for which no authority is cited, save that there is a reference to commercial rate of interest. Well, respect, the interest is payable in return for the lender making the money available. A person borrowing does not thereby become a purchaser of the money lent for value by any stretch of the imagination. But secondly, and more concerningly, this proposition is premised on the notion that when trust property is lent by a trustee, the beneficiary of the trust has no interest in the repayment of that loan unless the borrower had noticed that the funds being lent were trust property. Again, no authority is cited for this proposition, but certainly as I read Lord Millet's speech in Foskett and McKeer, and I've given the reference in paragraph 23.2 of my skeleton argument. I can turn it up if I'm asked to, but unless I can. The proposition is actually contradicted by Foskett and McKeer. The chain of reasoning whereby I said we only have to go as far as the loan agreement that Mr. Hay holds is the chain of reasoning in Foskett and McKeer. The example given by Lord Millet is of a lottery ticket. Trustee buys a lottery ticket, but misapplying trust property, and wins. The winnings are held on trust to the beneficiary. If a trustee buys life insurance, which was the facts of Foskett and McKeer, and the life insurance pays out, then the payout is held on trust. The next flaw in the reasoning is that it is suggested that sport capital is to be treated as an arm's length entity. Well, it's the defendant's money, a defendant's company. That's an agreed fact now. It used his money throughout. There's no evidence of it ever having undertaken any activity save to make and receive repayments of loans funded by the defendant. It's intended to return the funds to the defendant's use, and it's operated by a professional fiduciary. In our submission, the evidence suggests that sport capital is very far from being an arm's length entity, and that the defendant's knowledge has to be imputed to sport capital. So in any event, they could have been considered a bona fide purchase without notice. And then, perhaps the final point, the argument fails to address an established exception to the bona fide purchaser rule, which is that if a trust property is returned to the trustee, even if it's returned by a bona fide purchaser for value, then the title of the beneficiary is either revived or remains enforceable. In other words, it comes back into the pot. And the authority for that proposition is Independent Trustee Services and GP Noble Trustees Limited. Again, it's in your Honour's authorities bundle. I don't turn it up unless I'm asked. So, even if the argument were correct, as soon as money is returned to Mr. Hague, as it would have to be, it comes back into the pot as trust property. So whichever way one approaches the guy's solicitor's money, the sport capital money, in our submission, we have a strong proprietary claim to it, if our underlying claim is sound. As for the Cornish properties, they were paid for using our money, and we say we're entitled to trace it. And that applies to Trevorian Farm and the whole of the Cove. And so in our submission, the tracing remedy would normally follow from a breach of fiduciary duty. I hope that's not controversial law. And the answers that are put forward to the tracing claim, I should stop calling it a tracing claim because the other thing that was made abundantly clear in Foskett and McKeer is it's not a separate principle of law, it's a rule of evidence. Our entitlement to property has no coherent answer if our underlying claim succeeds. And in my submission, that is the foundation against which Your Honour considers this application for funding. summarise it in one sentence, a very strong prima facie claim answered in a way which is either incoherent or incredible, with no coherent answer to the inevitable proprietary consequences if that claim succeeded. Paragraphs 24 to 27 addresses failure to comply with the search order, which we say has simply been ignored, and the transfer of 2 apartments by the defendant to his sister. But there's no evidence of any money actually having changed hands. But Your Honour has already highlighted that both of those appear to be clear instances of contempt. Your Honour referred to us not having made applications for contempt. Well, Your Honour will appreciate the defendant is detained anyway. There is no sign of it by authorities releasing him. And were we to make such an application, it's likely to become a sideshow in a litigation with several sideshows already, which would significantly increase costs. We submit there is no answer to the contempt that is shown by the transfer of 2 apartments. If necessary, I can turn up the reference to KBH Canoe saying, in evidence to this court, that they had given him a brief outline of what happened at the hearing on the 3rd of June, the following day. So he was very well aware that a freezing order was in place. And if necessary, I can turn up the letter from Messrs. Stevenson Harwood dated the 4th of August of 2014, same day that the transfer was registered, which refers in terms to the freezing order. So they were certainly aware. Unless it's the defendant's case that Stevenson Harwood and KBH Canoe simply chose not to tell him that there was a freezing order in place on his assets, regardless of whether he had been served with a formal document, there were other issues. He was fully aware. Paragraph 28, I set out a number of the issues with the transfer in any event, but since Your Honour has said it's clearly in contempt, I don't need to take too much time over it. Then there are the remaining apartments in the freehold of the cove. As I said before, the short adjournment, owned by 4 companies between them, funded by the defendant in their entirety, now held, by a British Virgin Islands company called the Brendel Group, which until September 2013 was owned 100% by the defendant and thereafter transferred to his fiduciary, Chateau Fiduciaire. 4 companies who were directly ordered by Mr. Justice Flo to disclose the identity of their ultimate beneficial owner. They being UK registered companies, they were subject to the jurisdiction of the Commercial Court, and they were ordered to provide the identity of their ultimate beneficial owner. Well, the evidence that was filed in answer to that, Your Honour finds in our evidence, volume 2, page 581. As part of a sworn statement dated 19th of December of General Martel Welsh, who is the defendant's fiduciary. And paragraph 7, pursuant to 12.13 of the order, that's the disclosure obligation. Each of respondents 2 to 5 are wholly owned by Brindell Group Limited, a private company registered in the British Virgin Islands, and 100% of the issued share capital in each of respondents 2 to 5 is issued in Brindell directly. what that means. Although each of the 4 companies is recorded in Companies House as being owned by individuals, different individuals who appear to be nominees. It's asserted that in fact the share capital is held by Brendale Group. And then paragraph B, 100% of the issued share capital in Brendale is issued to Chateau Management Limited as nominee for CFSA as trustees of the 7th Trust, an irrevocable discretionary trust in proper law of Guernsey, of which CFSA is the trustee and no protector has been appointed. Respondents 2 to 5 consider that the ultimate beneficial owner of each of respondents 2 to 5 is CFSA as trustee of the trust. Clearly a contempt, again. Or at least it would be if Miss Martel Welsh has any understanding of the concept of ultimate beneficial owner. And if necessary, I can turn up her original witness statement of the 17th of June in these proceedings, in which, in relation to the ownership of Sport Capital Guernsey, Miss Martel Welsh said that Mr. Hague does not own Chateau Fiduciaire. And Sir John Chadwick described the statement as remarkable for what it didn't say.
I mean, this is water under the bridge to some extent, because I understand that Mr. Justice Rowe found that there was a good arguable case that all these properties belong to the defendant,
yes,
and that therefore they should be included expressly within the scope of the UK freezing order.
Now, this is water under the bridge, so far as we are concerned in securing those properties. But Your Honour is asked to consider a number of applications and the credibility of the defendant's evidence is to some extent an issue. As is the extent to which he has shown that he has no available assets. And even today there must be question marks over whether he is being candid with the court about what he does and doesn't have available to him, regardless of whether we claim it.
Yeah.
Paragraph 32 is my rather lengthy table, which I've taken you on through already. What is remarkable in my submission is that no real explanation is offered at all for this discrepancy. It is said that the defendant didn't have the opportunity to consider the September application in any detail before it was issued. Now, unless it's his case that Stevenson Harwood simply made up the application, they must have got this information from somewhere. And a very long list was drawn up. The December application, which exhibited chicken noodles and beef noodle receipts, those receipts must have been provided from somewhere before Mr. Hague filed a witness statement in this court in support of this application, asserting himself to be a lifelong vegetarian. It's unclear whether it's Mr. Hague's case that Stevenson Harwood were on a frolic of their own with both of those applications. But unless it is, in my submission, there is simply no coherent explanation for this, and it is not appropriate for a defendant to come to court asking for increasingly little amounts of money in the hope that eventually he'll persuade either the court or the claimant that it's not worth the candle and to allow him what he seeks. Similarly, must call into question the credibility of his application. As Your Honour identified, the point we make is there comes a point where you have to ask whether you can rely on anything that's said. And if Mr. Hague disowns what is said by his solicitors, then unless it's said that this application was made following proper opportunity to take instructions and can be adhered to, and some explanation is given as to why an application was issued in September, which bears no relationship whatever to the application now before Your Honour, then Your Honour is entitled to say this man cannot be relied on. I turn then, if I may, to the applications on their merits. Now, if I could deal firstly with the defendant's personal claim. Can I ask Your Honour to turn up our evidence volume 1? And go to pages 87 to 88. Now this is the defendant's UK HSBC bank account, for one of them. And we have the bank account for a period after his arrest. His arrest, as my friend has pointed out, was the 18th of May of 2014, which means that everything from about the bottom hole of the hole punch postdates the defendant's arrest. And Your Honour sees 2 payments on the 21st of May to Baker and Mackenzie, Aviva Mullah, and over the page, £10,000 to Asim Barclays, leaving a balance of £17,000. So it's quite clear that even after his arrest, he was able to operate his bank account. Now, the UK debts are put at £3,400. If Mr. Hague chose to dissipate assets immediately following his arrest, and chose not to dissipate them in favour of his legitimate creditors, in my submission he must bear the consequences.
Sorry, your reference to the UK debts,
that is his schedule.
£3,400, where do I see that?
That's his schedule.
That's the Schedule C, is it?
Yes, I believe so.
I've lost that.
Schedule C is appended to the draft order, which is behind divided true.
I've got you now, yes. So, and you're referring to, well,
But
the
there's,
it's 54,000, so what do we...
because does Your Honour see there is living expenses, a historic living expense allowance,
Right.
which I'll come to, Dubai debts, which I'll come to very briefly, and underneath UK debts.
Oh, okay, so it's those two,
Yes.
well, that's, in fact, oh, I see, that's dirhams, isn't it?
They're dirhams.
Yeah.
So they equate to, well, we've got £3,414. Well, if Mr. Hague was in the business of dissipating £10,000 in the days following his arrest to an unidentified third party, and he chose not to dissipate his money in favour of his legitimate creditors, then he must bear the consequences in my submission.
Right.
So far as the Dubai debts are concerned, while we have Schedule C open, Your Honour has already indicated...
Well, I've really covered 2, 3, 4.
And 6.
And 6.
Yes.
What do we do about 5?
Well, Your Honour, the credit card debt was part of the application in September.
Yes, I sort of distantly remember that, but I can't remember that.
I think it rather fell into the background as Your Honour challenged my learned friend's predecessor on a number of other aspects of the case. The debt amounts to somewhere of the order of £10,000. His bank account was being operated in the period between his arrest and our being able to come before this court to secure a freezing order. Same point. If he chose not to pay his debts, because it's unlikely that he's incurred a £10,000 credit card bill in prison. He's got nowhere to use it.
No, I assume this is a debt due as at the time of his arrest.
Yes. Now, firstly, that, as my learned friend points out, is 10 months ago, with no sign of anybody taking proceedings against him. But secondly, if he was in the business of dissipating his assets immediately following his arrest, and he chose not to dissipate them in favour of a credit card company to whom he had given a cheque guarantee, no doubt fully aware of the consequences of that cheque being dishonoured, then he must bear the consequences.
Yeah.
And finally, as regards Schedule C, the historic living expenses.
Yeah. Now, is that itemised somewhere?
It's simply, as I understand it, what that is several weeks at $500.
Oh, I see. So what is said, sorry, I misunderstood that. So what's it's since he was allowed to spend $500,
yes.
He says that he actually hasn't himself funded that. He's received help from family or friends who've given him the $500, and he wants to repay them. Is that as you understood it?
That's as I understand it too. Now,
and what's the position about that?
Can I ask you on to turn?
We're talking a total there of, I'd like to use in dollars or pounds, that's it's about £5,000.
Thereabouts,
Yeah.
5.5.
Yeah.
Can I ask Your Honour to turn up our authorities bundle, which came with the additional?
Yes.
Volume which? 2, is it?
No, it's the it says authorities. Authorities bundle for hearing on Monday 23rd. It came with the additional.
Yes, I've got it.
Could I ask Your Honour to turn to provider 5?
Cantor and Lister.
Yes, Cantor and Lister is of course a very well-known authority for the proposition that a defendant who gets into debt unsecured does not thereby breach a freedom order. But
I'm not actually familiar with the case. Proposition being what?
The facts of the case were that the defendant incurred new debts after the imposition of the freezing order.
Yes.
And applied for permission to use some money. But a point was taken that he was in breach of the freezing order by getting himself further into debt, indirectly dissipating his assets. And
well, if it was in the ordinary course of business.
Well, no, the conclusion of Mr. Justice Newberger, as very much he then was, since approved by the Court of Appeal in the Ablyazov, one of the many Ablyazov decisions, was that a person who gets themselves into debt does not thereby violate a freezing order.
Because you don't.
It's a person who pays debts without permission.
Yeah, well, that's a bit odd. Yes, okay.
Anyway,
you're reading it.
But the authority is useful for this context to some of the later issues. And if I could ask you to turn to page 220.
Yeah.
And under the heading Issue E,
Yeah.
is the defendant entitled to claim, as it were, retrospectively the £500 per week under paragraph 3.1 of the freezing order? And perhaps I stand silent while Your Honour reads those two paragraphs.
important verb might be entitled.
Yes.
I don't think there's any evidence that the defendant is entitled to borrow this money off his family and friends. So, is this point in place? This, as I understand it, is, well, if you can borrow money from a third party because they've agreed to lend you money, and you use that money to live with, you can't come along to the court and say, I need money to repay him because I now want to use the money that's frozen. And I'll say, no, you can't do that because you literally avoided the problem.
Yes.
Now that's not this case, is it? Or is it?
Well, that appears to be what Mr. Hague is asking for.
No, I'm sorry, I think maybe it must be a cross purpose.
I think
the sentence that caught my eye was, if the defendant, as he has chosen to do in this case,
yes,
is entitled and able to borrow from third parties for the purpose of living, and he chooses to take that course, that is his lawful choice.
Yes.
Now here, the defendant is able to borrow, but I've no reason to think he's entitled to borrow.
Your Honour, as I read that sentence, if the defendant is, well, the entitled is a reference to the earlier question of whether the defendant is entitled to get himself into debt at all when a freezing order is in place.
Oh, I see. It doesn't mean entitled to borrow.
It doesn't mean there is a loan agreement in place.
Oh, I see. So that's what threw.
So he's permitted to borrow by the freezing order.
He's entitled to get the money, and he's able to get it somewhere else. Yes,
if he's able to get the money somewhere else, he doesn't breach the freezing order by doing so. Yeah. What he's not entitled to do is to then come along and retrospectively ask the court to sanction the payment of those very living expenses from frozen money.
Well, Mr. Rowley, you'll have to help me a bit like that. That's a point which is new to me. Yeah, thank you.
And so that, in my submission, addresses the living expenses. The ongoing Dubai commitments, Your Honour has already referred to them, because they're all related to the property.
So and down to legal expenses. Right?
And so one turns to legal expenses. Now my friend drew a comparison with the claimant. From my submission, there is no such comparison at all. We are firstly the claimant, with all that goes with that. Secondly, we have to build a case with very little help from the defendant. We have had to chase assets in the teeth of opposition from the defendant. And can I give Your Honour a page reference? I won't turn it up now, I've been on my feet for a long time. Page reference is DJW1, page 663, and it is in volume 2 of our evidence in response. What that is a witness statement from Mr. Chan of Chan Neal Solicitors, in which he asks that Stevenson Harwood be made to pay his costs of complying with a disclosure order in the commercial.
Yes, well, I've read about that. Yeah.
So it went that far. We've had to pursue letters of request because for the defendant's bank accounts, the defendant even saw fit to withhold them from his own forensic accountant. And I'll give you a page reference, DJW1, page 820, in volume 3. And I'll just double check my own annotation. Yes, page 820. This is a list of documents that PwC asked for in order to complete their report. And if you want to see the last two entries, access to original bank statements of accounts held by Mr. Hague during the period, including those that have been closed, access to all statements of personal credit cards of Mr. Hague. So he didn't even give them to his own forensic accountant, much less give them to us.
Yeah.
And of course, we've had to put before the court the full facts of the case more than one occasion. So no proper comparison in my submission arises. The application that I'm meeting is a very much smaller application than the one I came to meet. Because the one I came to meet was for permission to spend up to approximately £2.5 million.
Right.
Now I'm meeting one for £500,000, and instead of an application for permission to spend money on a total of 6 sets of proceedings, I'm facing an application for permission to spend money on 2 sets of proceedings. In my submission, Your Honour made the point this morning. This is a drop in the ocean if Mr. Sethi's evidence is right. Even on this claim, it simply doesn't begin to cover the full extent of the costs that he sought. And I can take Your Honour through
Well, that is
so beginning at page 12,
yes,
behind divided 3,
the main claim
as he keeps
was
calling it.
950,000 so far.
Well, no, it's 1,030,000
Is that on this claim?
in total. 950,000 on this claim.
This claim,
Yes.
right. Including the criminal proceedings, yeah.
Yes. Then council's fees.
Council's fees, that's all in relation to.
Well, I don't want to embarrass the friends. They relate to a number of features, number of
Well,
aspects.
there's council's fees and local,
Then local council's fees.
and then some expenses have been paid.
Yes.
So,
Now,
I mean, the total already spent,
we guesstimate 1.35 to 1.4 million pounds.
£1.4 million. And then the
And
future,
then going forward,
is another.
as it's described, the main claim is another £850,000.
And 300,000 for criminal proceedings.
Yes.
So 1.2 million.
Yes. Now, it may be purely forensic point, but much has been made, both in court and in terms of publicity, of Mr. Hague being detained without charge or questioning, effectively detained in breach of fundamental right.
Yeah.
One has to ask if nothing's been happening, how those criminal lawyers run up £100,000 worth of costs. Outstanding. That's Nassim Malala, local council.
Well, yeah.
So, Your Honour, the fundamental point about even £500,000, it simply doesn't begin to answer how Mr. Hague is going to meet the extraordinary costs that he anticipates of this litigation. And indeed, Mr. Chandrasekhar's answer to where he was going to find the additional £1 to £1.5 million that is referred to in Mr. Sethi's statement was he's not. If these cases go to trial, his lawyers won't be paid. Well, presumably they expected that. So the question that's posited quite rightly in my submission by the learned friend is not, will the lawyers be paid? The question is, will the defendant be unable to secure a defence to the claim? And by that I mean properly engage with the proceedings. If I take a point against myself for a moment, but it's very fair, it's very right that I do. My friend referred to Article 6 of the European Convention. Obviously the Convention has no direct application in this court, but of course Your Honour is very well aware that Article 6 adds very little to the common law duty to ensure a fair trial. But against that background, of course, Your Honour is also well aware of the overriding objective in both the civil procedure rules and, more importantly, the rules of the DIFC court. Those include the duty to deal with cases fairly, which means fairly as between both parties, not just to the defendant, and proportionately. As in a proportionate cost to the issues at stake, and devoting appropriate amounts of resources. Now, we say, Your Honour, we made £200,000 available. Mr. Hague appears to have another £200,000 over which we cannot mount a proprietary claim. But
Well, that's the flat.
yes,
Yeah.
and which he asked for Your Honour's permission to sell nearly 6 months ago, and now says actually he wants to live in it if he's released. It's not just the complete false pass as to what is happening with the mortgagee. He also says he wants to live in it until the property is sold. And we say that enough is enough.
Yeah.
It should not be allowed to use what is effectively our money to continue to give us the runaround on an incoherent defence. Unless I can assist.
Yeah, that's very helpful. Thank you very much. Yes, Mr. Ali.
Your Honour, may I first direct you on to our divider 6, please?
Yes. Well, exhibit DH1.
Yes, page 117. There's a bit of confusion with regards to the expenses. Page 117 gives a total of 903.86 at the bottom of the page. If Your Honour turns over to page 118, these are the defendant's ongoing monthly commitments whilst incarcerated, Schedule 2. That is calculated in dirhams, 23,884.37.
Yes.
And if that figure, 23,884.37, is divided by 4, added to the defendant's monthly expenses in Burdeby Police Station.
Sorry, say that again. If you divide that before and add it to what?
Add it to the monthly expenses in Burdeby Police Station, which is 903.86 weekly. That will explain the figure behind tab 2, page 4, 2528.65.
Oh, I see. Yeah. So you're saying the 2528 is 900 plus Corsa
Yes,
of the other.
Indeed.
Yeah, I get you. I understand.
thank
Yeah,
you.
okay. Thank you.
Your Honour, I'm not going to spend too long on chicken soup and beef soup and vegetarianism. I think the point is that Mr. Hague suffered a stomach operation which left him very unwell, and he was unable to eat solid foods. Soup was consumed by him, chicken soup and beef soup. That is not inconsistent with being a vegetarian. And if instructions have been lost in translation, the defendant, in my respectful submission, should not be prejudiced by that. He is unwell and he is on a restricted soft food diet. But I'll move on from there.
Yeah.
Your Honour has the handwriting expert report now, I understand. I have a copy here. It wasn't within our variation bundle, but I can...
But the handwriting?
Yes.
Yeah. Yeah. Well, I mean, it's attached to the defence, as I understand it.
It is attached to
the PwC report as well, which I haven't looked at. Yeah.
Both reports are attached to the defence bundle, not the variation bundle.
I follow, yeah.
And Your Honour, the issue really for the main claim and the criminal charges that Mr. Haig faces is this. There simply are no funds. Mr. Haig has no money. He cannot pay his lawyers. Now, imminently, Mr. Haig faces an immediate judgment hearing in May, I understand. Yesterday, those who instruct me received an expert report written in Arabic script in relation to the criminal matters Mr. Haig faces. It is true many lawyers...
Sorry, this is a report produced for who?
Which was served on those who instruct me.
So prepared by the prosecution?
Prepared by...
I can assist you on an expert forensic accountant was appointed by the state prosecutor to investigate some of the circumstances of the case. He finally presented his report to the prosecutor and the parties. I believe it was late on Thursday.
Right.
We didn't put it before you on it because it doesn't take the case.
I'm just slightly puzzled how you have a report on a non-existent charge.
It's a very different system in the United Arab Emirates.
Yes, anyway.
And it also records the multiple conversations with the defendant's lawyers.
Well, it is a very different...
I'm sorry, but your point is what?
Well, that report has been served in
Yes.
Arabic. Mr. Haig has no funds for that report to be translated into English.
Right.
It's a 1,000-page report. I'm just highlighting the problems Mr. Haig has with his legal position and not having the funds to pay lawyers. My learned friend said the costs of those who instruct him bear no comparison to the costs Mr. Haig faces. Well, in terms of costs, at the variation hearing, the claimant's legal costs were $198,000, and I've already intimated that if that's compared to the £200,000 released for legal expenses by this court in September, it's not difficult to see how the defendant has run out of money. But my learned friend is right, there is no comparison because on other aspects, because we have a client who is locked up, has been in custody now for a month shy of a year. On any view, it is very difficult to see and take instructions from him. If I am right, Your Honour, and the lawyers who currently act for Mr. Haig down tools, if the worst case scenario comes to fruition, we will have a man who's facing the main claim with no representation. He will be facing criminal charges in a foreign country where the court procedure is in Arabic. All documents are written in Arabic. She's unable to read. That will be the scenario. And as my own friend has conceded, Mr. Haig is not going to be released anytime soon. So he will languish in prison with no representation whatsoever. Your Honour asked me for a figure. I put forward £500,000 as a suggestion to keep those instructed working for Mr. Haig. Of course, all the lawyers know this money is frozen. lawyers, as Your Honour knows, will not carry on working indefinitely for no consideration. And that time has come when lawyers, in my submission, will now down tools, and Mr. Hague will be left to fend for himself, which would be a most unfortunate situation. I don't know if there are any other points Your Honour wishes me to address you on.
Right, is that it?
That is it.
Thank you. Well, this is a matter of some importance, not least to the defendant, of some significance within the Emirate, and for reasons which are obvious, of some significance in London. I appreciate Council are leaving tonight for London, and I hope they won't mind if I say I'm going to think about it overnight, and I'll give a judgment in the morning. I won't take it to the slightest offence if you're not here. You'll no doubt get at least a summary of it pretty quickly. And I'm grateful to your assistance. Thank you very much.
Would Your Honour say that any consequential matters will be dealt with in writing? I have in mind two. One is costs, and the other is the issue about the way in which Trevorian Farm is to be dealt with if it is to be sold.
Sorry, the last point?
The way in which Trevorian Farm is to be dealt with if it is to be sold.
Oh, I see, yeah. Leaving that point aside, it may well be our form of view of what the costs position should be, and we'll make a provisional indication subject to further submission. That seems the more cost-effective way of dealing with this. Okay. Now, there is, as I understand it, on the cards, an application for what is called immediate judgment here. That's, I think, being fixed for some days in May, right? The rules have some provision as to the procedure for an immediate judgment application. Part 24.
Yes, I can assist Your Honour to this extent. This application was mooted at the CMC, and directions were given in relation to it.
So that's all, the timetable is set?
Yes.
So I don't have to think about that at all. Okay. And so far as any substantive hearing, that would obviously await the outcome of the application for immediate judgment. Correct. Okay. Well, I don't think there's anything else, or nothing else occurs to me anyway. Thank you both very much.
All right.
We're getting out as fast as we can.